So hello everyone. For this presentation, I'm going to focus on a particular legal aspect that we analyzed during the BeSocial project, and which constitutes currently one of the biggest challenges for social media archiving. So that legal aspect is copyright law. Within the BeSocial project, the legal aspects of social media archiving were obviously analyzed, so in order to ensure that we were compliant with both European and national law. As part of this analysis, we studied data protection rules with the application of the GDPR. We also studied the privacy rights of individuals and how it could collide with the right to information of the public and the right to access the archives. We also studied open data considerations and then finally copyright matters. So among all these legal aspects of social media archiving, copyright is probably the biggest obstacle we currently face. Indeed, these particular rules are an example of the law's inability to sometimes adapt to digital evolutions. And this is why I have chosen that particular to discuss during this presentation. I've also chosen it because of the fact that it's mostly a European regulated field, because directives have been adopted on the matter. So these directives had to be implemented by member states with some room for maneuver. So this framework can be relevant for a large amount of countries. I will therefore focus mainly on the European rules and will only mention Belgian applications occasionally. All these considerations can also apply to the archiving of born digital content in general, so they are not limited to social media archiving in particular. So to start from the beginning, I will tell you a little about what is copyright law and why it exists. So as you are probably already aware, a copyright can be awarded to the author of a work as soon as two conditions are met. These copyrights will act as a protection of that author by granting them several prerogatives on their work. So copyright is supposed to encourage creation by protecting the authors of those creations. So the conditions for a particular work to be protected are the following. So first of all, the subject matter has to be original, and this means that it must reflect the personality of the author as an expression of free and creative choices. So to go a bit further, we can say that a work will not be considered as creative if it is the result of technical constraints, so we need a bit of free choices. So for example, for a picture, the choice of light, or for text, the choice of words can be considered as creative. Second, a work has to be considered as a work, which means that it must be the expression of a creation, and a simple idea cannot be considered as a work, it must be expressed. Following these conditions, works that are protected by a copyright can take various forms, for example, text, pictures, sculptures, etc. So when these two conditions are met, a work is protected by a copyright automatically, so without having to do any legal process to obtain a copyright. And this entails that the author, or whoever the copyright has been transferred to, has to give their authorization for several actions related to that work. So notably, it will have to authorize the reproduction of the work or its communication to the public. So it's also important to add that such an authorization must follow an opt-in principle rather than an opt-out, which means that the authorization must be obtained before doing any of those actions. We cannot, for example, collect, reproduce, communicate the work of someone, notify them and wait for them to say that they do not agree. We have to obtain their firm authorization beforehand. So following all these considerations, it's quite obvious that social media contain a lot of works that are protected by copyright. So this includes both pictures and texts. And furthermore, collecting social media content to archive them represents a reproduction of it, which requires the author's authorization. And deciding to make the archives accessible to the public will then represent a communication to the public that also has to be authorized. So as those criteria can be quite difficult to apply and can seem a bit subjective, it entails that it seems impossible to use a software of some kind that would determine in which cases social media content is indeed protected by a copyright and would require therefore an authorization to produce it. Indeed, a simple hashtag, for example, can be considered as protected if it is creative, because the creative character of a work doesn't depend on its length. So even a few words can be creative. Therefore, copyright law, we think, has to be respected for all the social media content archived in order to make sure that we do not reproduce content illegally. To this, we also have to add the fact that we cannot be sure that the owner of the account who posted the content is actually the owner of the copyright on that content, because as I mentioned previously, a copyright can be transferred to someone else. And so the owner of the account on which it has been posted could, for example, hold a license over the work that does not allow him or her to authorize the reproduction of the content. They could also not rightfully have posted the content in the first place. So with all these elements in mind, you can have a feel of the difficulty that copyright law brings into social media archiving practices. So fortunately, or so we could think, there are exceptions to copyright rules that exist particularly for archiving practices in European law. There are exemptions to both of the rights I mentioned, so the right to authorize a reproduction and the communication of a work. When it comes to the communication to the public, Directive 2001/29 prescribes that protected work can be communicated for the purpose of research or private study by publicly accessible libraries, educational establishments, museums, or archives. However, that communication as part of the archives has to be limited to dedicated terminals on the premises of the establishments, so in our cases only at the library. This exception can be applied to digital archiving, so we will not spend too much time on it because it's actually useful in our case. An exception has also been provided in Directive 2001 also to the reproduction rights of author, which allows member states to integrate such an exception in the national law. So this exception allows publicly accessible libraries, educational establishments, museums, or archives to reproduce protected content without an authorization, but not for a direct or indirect economic or commercial advantage. However, there is a rule in copyright law according to which the exceptions to copyright rules must be interpreted restrictively, so word for word. And when it comes to this particular exception to the reproduction right, it was said in the recitals of the directive that should not cover uses made in the context of online delivery of protected works or other subject matters, which makes it useless when it comes to digital archiving, because it is inapplicable to the archiving of born digital content. We could have hoped that the new directive that was adopted in 2019, in order to precisely tackle copyright matters in the digital world, and particularly around platforms, we could have hoped that this directive would have taken this problem into consideration. However, there is a new exception provided, which is imposed to member states in that directive for cultural heritage institutions, but this exception is restricted as it only applies to copies made of works which are already in these institutions' collections. So this is specified as a case where the institution already have copies of the work, and this exception is meant to ensure the preservation of copies against technological obsolescence, for example, or degradation of original support. Nevertheless, some member states still extended the exception to the reproduction right from the 2001 directive that I mentioned previously. So they extended it to the archiving of digital content, notably in their laws on legal deposit. So it is, for example, the case in France. So extending such an exception is quite logical when you intend to archive digital content, because having to obtain authorization from all authors of work in such a context is obviously inoperable, and it does not preclude the need of these institutions to preserve social media content for cultural heritage purposes. Some solutions that could be envisaged to still benefit from these exceptions is first that we could think that we can do an evolutive interpretation of the directive from 2001, because it's rather old and the world has evolved a lot since then. We could also say that the precision on archiving of digital content was made in the recital of the directive, so a recital is not technically mandatory. However, considering the principle that is applicable to the exceptions to copyright law, it does not seem very promising to envisage such solutions. So to summarize, the digital evolutions are a challenge for the application of the law, and digital archiving practices are no exception to that. And this is particularly the case when are of strict interpretation, because you cannot interpret them in an evolved way. And it is the case for copyright rules, obviously. So even if we could find some alternative explanations to use these exceptions, it would still lack legal certainty. And it would be, according to us, very important and necessary for the European legislator to take the archiving of digital content into account and extend that exception to it. So it would make the life of public institutions that wish to archive it more easy. Thank you very much for listening to this presentation.